Hello and welcome. Good morning, good afternoon, good evening, wherever you may be, whatever the case may be. We are joining you from Bishkek Arbitration Days. This is the fourth and final session. I hope that you've been following along from wherever you may be, just as I have been, and that you've enjoyed the panelists and presentations so far. The subject of this session, of session 4, is investor-state dispute settlement. Who knows what tomorrow holds? So we will have a very engaging discussion with my distinguished colleagues, who I'll introduce to you in a moment, about some emerging issues in this area of practice. So I'll start by thanking our hosts very kindly, both Putilin Sipol and also American University in Central Asia, as well as our great colleagues who are at both of these institutions. So Elia Putilin, Sultan Khalilov, and also Khaneke Kasibekova. So thank you on behalf of all of us for all the hard work that you've done to bring everybody together and create this great opportunity for us from a global platform. So now let me introduce you to my distinguished colleagues. You will notice that there is a theme. I won't tell you what the theme is, but there is a theme among them, and they're all immensely qualified and very well regarded in the field. So I'll start in the order of presentations that you'll hear from them today. I have first Evgeniya Rubinina. She's a partner at ENYO Law, a London disputes boutique. She has more than a decade of experience representing companies, individuals, and governments in international arbitrations, both commercial disputes and investment disputes. She is triple qualified in England and Wales, New York, and Russia. And before she joined ENYO Law, she was at Freshfields in London and Paris. She's also previously worked at ICSID, The Hague, the Permanent Court of Arbitration, and also holds degrees from Moscow State Institute of International Relations, Oxford, and Harvard Law School. So Evgeniya, we're so happy to have you here with us today. Next, I'll introduce my colleague, Professor Dr. Islambek Rustambekov. He is currently Deputy Rector for Academic Affairs at Tashkent State University of Law and the immediate past head of Department of Legal Protection of Interests in the Republic of Uzbekistan, focusing on international and foreign organizations at the Ministry of Justice. He is trilingual. He speaks Uzbek, Russian, and English. Today, of course, we're doing this in English. And Professor Rustambekov has significant experience representing both the Republic of Uzbekistan and its state-owned enterprises in important investor, state, and commercial disputes. He regularly also sits as an arbitrator and is often retained as an expert in public international law and also on the laws of the former Soviet Union republics. Next, we have my colleague Kabir Duggal. He practices, again, international investment arbitration, commercial arbitration, and public international law disputes. His experience flows from his triple training. So he's triple trained in international law, common law, and civil law traditions. And the total value of the disputes that he's overseen in his career exceeds an impressive 80 billion. So his clients are very happy to trust him with very important matters. He has a number of accolades and is highly ranked by leading publications and institutions. And he's most notably of which he's considered a rising star by many of them. Super lawyer, rising star, whatever the description you want to use. I think Kabir has earned that distinction. Finally, last but not least, we have our colleague Monica Feria-Tinta. She's a barrister at the Bar of England and Wales, practicing in public and international law and international arbitration from 20 Essex, which is a leading commercial chambers in London. She acts for sovereign states, international organizations, and private parties in domestic and international proceedings, including in the courts of England, international courts, and before other kinds of tribunals. She's appeared in commercial arbitrations as well as investment arbitrations, as I said, and she is trained not only in the common and civil law tradition, but she's another one who's triple lingual. So she speaks English, Spanish, and French. She's a partner fellow at the Lauterbach Center of International Law and also a guest lecturer at their executive course on investment law and arbitration. She's a member of the Chartered Institute, holds an LLM from the London School of Economics, and also a diploma from the Hague Academy of International Law. So welcome, Monica. Last but not least, I'm finally going to introduce myself. My name is Kiran Gore. I am joining you from Washington, D.C. I'm a U.S.-trained New York lawyer. I focus my practice on international dispute resolution, including international litigation in the U.S. courts, commercial arbitrations, investor-state disputes, and I've done this work in both large firms and small firms in the United States. I represent clients in a variety of really interesting industries, and I also teach at GW Law School, the George Washington University Law School, and New York University's Washington, D.C. campus. I am more than thrilled to be your moderator here today on this really exciting panel, really timely panel. Our topic, again, is investor-state dispute settlement. Who knows what tomorrow holds? And before I turn the mic over to each of my panelists in seriatim, what I'd like to do is set the stage for you. So before I proceed, let me just say that all of us here today are speaking in our personal capacity. We do, although we've told you all our various affiliations and institutions with which we have connections, we're not speaking on behalf of any of them, and nor are we speaking on behalf of any of our current or former clients. So please take these as personal views. So the question that I'd like to pose to all of you today against the theme for today, which is who knows what tomorrow holds for investor-state dispute settlement, is investor-state dispute settlement, ISDS for short, still fit for purpose? And this question comes from the central debate that many of us are familiar with, many of us have heard, which is after several decades of use and experience, the users of the ISDS system are beginning to question whether it still serves the goals that it initially was set out to achieve. So ISDS, as you know, it's not only a mechanism that you would find in an individual treaty, multilateral or bilateral treaty, but it's also a system. The network of all these mechanisms taken together create a network of a system of ISDS, and the common criticisms that come are interesting because there's many repeat users. As you heard me when I was describing the introductions to each of my panelists, there are many users who are repeat players, not only states, but also investors around the world. And so these criticisms are not to be taken lightly. A lot of the criticisms are fundamental, and some of them are a little simpler. So on the fundamental side, you have a complete disagreement with the system and how it's set up. You know, some opponents will argue that foreign investors should not be permitted to challenge possibly domestic legitimate regulations, that arbitrators are inherently biased in claimants' favor and therefore ill-equipped to render these important decisions, which involve the use of public funds, or that the lack of consistency among ISDS decisions undermines the system as a whole. These are fundamental questions. They're hard to tackle. They're hard to answer when you're trying to engage with a system that already exists. Meanwhile, there are other questions that maybe are simpler or easier to tackle. They might concern transparency, cost, and time associated with individual proceedings, or the need for an appellate review mechanism. So these are more digestible, these concerns are digestible, and maybe solutions can be devised more easily. These are precisely the same questions that are currently being considered at ICSID as part of its rule amendment system, or a project that they're working on, and also by UNCITRAL's Working Group 3. What's interesting is that both of these initiatives begin with a single premise, which is that modernizing the current system generally and reforming specific mechanisms can address the stakeholders' concerns. And as I've said, many of these stakeholders are repeat players. So what we have here is the various stakeholders coming together and drawing upon what I like to call their experiential reality. After decades of use, after all of this experience that they've had in resolving specific disputes and engaging with the system, they are exponentially trying to figure out, how do we make the system work for us? So they really are focused on not throwing the system away, but how do we make the system work for us? And this principle comes from the idea that a state's decision to include an ISDS mechanism in its international investment agreements, whether they're multilateral or bilateral, reflects a calculated decision to accede a piece of its sovereignty to attract foreign investment and development and increase global trade. So while starting from this point, it's important to remember that many of the criticisms can be dispelled, and there's a systemic approach to trying to address those concerns. So I'll give you one example. In 2015, the International Bar Association, the IBA, published a short fact sheet that sought to clarify some misinformation. So for example, it explained that over time, states have won a higher percentage of cases than investors. Investors rarely recover windfall damages, and in all events, states retain the right to regulate in the public interest. And separate from this, states also retain the right to walk away from certain treaty obligations that they've negotiated through the renegotiation or modernization process. And this is something that we're seeing in the United States and in North America generally, with NAFTA coming to an end on July 1st, and the US-Canada-Mexico agreement coming in as its replacement also on that same date on July 1st. So against this backdrop, this is also where we start. So we start, all of my panelists, and you'll hear from each of them now, they start with the same principles as the ICSID Rule Amendment Project and also UNCITRAL Working Group 3, which is that reform and modernization of the system and also of specific mechanisms can help address stakeholders' concerns. But the question is, how do you do that? How do you keep the system that we have fit for purpose? So from that point, I'd like to segue to my colleague Evgeniya, who will address this from a particular topical lens. She'll focus on corruption allegations and investment arbitration proceedings, in particular, not only with respect to procurement of such investments, but also execution of investments and other stages of the proceedings. And Evgeniya will draw upon what I call the experiential reality to address some of these important concerns and try to discuss what this means for the public and private sector and what this means for the precedent and case law that we do have through this experiential reality. So with that, Evgeniya, I turn it over to you.
Thank you very much, Kiran. And it is a great honor and pleasure to be appearing in the virtual Bishkek arbitration days. As Kiran helpfully set out, there's a number of areas in which the investor-state dispute resolution system is in need of reform. And one area in which it is particularly difficult to reach a solution that would satisfy all the stakeholders is the way in which international investment arbitral tribunals deal with allegations of bribery and corruption. On one hand, there is broad consensus that investment treaty arbitration should not be a vehicle that allows investors who have paid bribes to benefit, because that would encourage corruption, give it effectively a green light. On the other hand, completely rejecting claims by investors on the basis of corruption allegations by host states effectively allows states to benefit from their own officials' corruption, therefore exempting them from liability in situations where they otherwise could potentially be deemed to be in breach of their investment treaty obligations and held liable for damages for many millions of dollars. I will explore this tension in my presentation. I should note from the outset that the issue of corruption is of particular interest to the Central Asian region, as this has been a very popular defense raised by Central Asian states in investment treaty arbitrations brought against them. And it has also been an issue raised by investors in claims brought against Central Asian states. Uzbekistan in particular has raised the corruption defense in at least 3 publicly known cases, Metaltech, Kim, and Spentex. Kyrgyzstan has raised it in at least one case, System in Kyrgyzstan, and also allegations of systemic corruption were made against Kazakhstan by investors in the case of Liman against Kazakhstan. In my presentation, I will first give an overview of the circumstances in which corruption can be relevant in investment treaty arbitration. I will then trace the evolution of the tribunal's approaches to corruption and look at what the most recent tribunals have done and try and divine from that where tribunals are moving in that respect. So what are the main scenarios in which corruption can come up in investment treaty arbitration? Number one is corruption on the part of the investor, and that could happen at the outset of the investment when the investment is first made in the host state, or it could happen during the life and operation of the investment. So when a bribe is paid at the outset of the investment, the investor effectively paid an entry ticket for investing in a country by bribing government officials. And a textbook example of that is the famous World Duty Free and Kenya case. In that case, a representative of World Duty Free came to a meeting with the president of Kenya carrying a brown leather suitcase full of cash containing $500,000. And at the end of the meeting, the investor picked up the suitcase and later noticed that the cash had been replaced by fresh corn. So in that very blatant example, the tribunal considered that the investment had been tainted by bribery, which is contrary to international public policy, and declined the claim. Now, World Duty Free is actually a contractual claim governed by English law, but it was heard at ICSID because there was an ICSID clause in the relevant agreement. But even though it was effectively an arbitration under English law, this has been a very influential case, and it has been cited by many investment treaty tribunals that followed it. So in the framework of investment treaty arbitration, a corruption defense at the outset of the investment can be made within two types of scenarios. One would be in cases heard under investment treaties that contain a legality requirement as part of their definition of investment. And investment is defined as investment made in accordance with the laws of the whole state. And I note in particular that Uzbekistan's bilateral investment treaties generally contain that language. So in which case, if there is a suspicion of bribery or corruption, the state argues that the investment was not made in accordance with the laws of the host state. When cases are heard under investment treaties that do not contain such express language, tribunals have been quite willing to imply the prohibition of corruption into investment treaties by referring to World Duty Free and saying that the prohibition of corruption is part of international public policy, and therefore that claims in relation to investments tainted by corruption cannot be heard. They're either inadmissible or outside the jurisdiction of the tribunal. So the second broad type of scenarios is corruption during the life of the investment. So what happens if an investor pays a bribe after initially investing in the country, for example, to renew a license or to maintain the investment in that country? And here the outcome is drastically different. Tribunals have generally held that illegality committed after the investment was first made does not deprive the tribunal of jurisdiction and does not make the claim inadmissible. It is simply one of the factors that can be taken into account at the merit stage or in the quantification of damages. For example, in the UCOS case, the tribunal famously reduced the amount of damages payable to the investor on the basis that the UCOS companies had breached Russian tax rules and therefore committed an illegality, but that was during the life of the investment. And the tribunal determined that it was contributory negligence of sorts and reduced the amounts payable to the investors by a certain percentage. So is this the correct outcome from a policy perspective? If investment treaty tribunals want to give a strong message that corruption and bribery are not acceptable features of international investment, of international trade, why is it acceptable for an investor to commit bribery after the investment is made, but why is it so unacceptable to commit bribery at the outset of the investment? And to an extent, it is a legal fiction of a kind to be drawing a very harsh distinction between these two types of corruption. But here's where we are as a matter of law, and I can't really see that changing unless provisions are introduced in investment treaties that deal with these issues in a particular way. So far, we have talked about investments about corruption by the investor. What about corruption on the part of the state? Allegations are quite frequently brought by investors as well that state officials, for example, try to extort bribes from investors. And in some circumstances, these incidents could form part of a factual matrix of a breach of an investment treaty obligation by a state. For example, if a corrupt official asked for a bribe, the bribe was not paid, and that by way of retaliation, the state took measures that were adverse to the investment. The main difficulty here is attribution. Under the customary international law of state responsibility, a state is not responsible for ultra-virus acts of its officials, and taking bribes would most certainly be ultra-virus. In the remaining time, I will focus on the corruption defense raised by states against investors, and I will track how tribunals have dealt with corruption allegations and how that approach has evolved over the last 14 years since World Duty Free. So World Duty Free, the facts of which I have already described, will be the starting point for my analysis. This is the first known award in which a claim was declined based on the investor's corruption. Not that states didn't try before to kick out claims on the basis of the corruption defense. For example, in Wiener hotels and Egypt, the state raised some corruption allegations against the investor, but they were unsuccessful. The state bears the burden of proof in relation to the corruption defense. And due to the nature of corruption, it is obviously very, very difficult for the state to have access to all the evidence in order to be able to prove that corruption was committed. So this all changed in 2013 in a case involving Uzbekistan, the famous case of Metaltech and Uzbekistan. In that case, the tribunal took a novel and proactive approach to establishing whether corruption had taken place. Metaltech is an Israeli company who brought a claim alleging that Uzbekistan had nationalized its share in a molybdenum concession. And then it subsequently transpired that Metaltech had paid $4 million to a number of well-connected local advisors, one of which was the brother of the then Prime Minister of Uzbekistan, who had no relevant qualifications or experience in the molybdenum industry. The tribunal in that case considered that these payments constituted certain red flags and asked the claimant for explanations regarding the purpose of these payments. While in that case, the tribunal did not expressly shift the burden of proof from the state to the investor in relation to the corruption allegations, it nevertheless was not satisfied with the explanations that were given in regards to the nature and reasons for these payments, and found that corruption had taken place and declined jurisdiction over the claim. At the same time, the tribunal in Metaltech accepted that it was quite a harsh outcome. It noted that it was sensitive to the ongoing debate that findings on corruption often come down heavily on claimants, while possibly exonerating defendants that may themselves have been involved in the corrupt acts. And it then proceeded to say that the idea is not to punish one party at the cost of the other, but rather to ensure the promotion of the rule of law, which entails that a court or tribunal cannot grant assistance to a party that has engaged in a corrupt act. The Metaltech Award can be said to be something of a high watermark in tribunal activism in establishing corruption and rejecting claims by investors on that basis. All corruption cases are extremely fact-specific, but it does seem that in some of the subsequent awards, tribunals were a bit more circumspect about finding what sort of actions amounted to corruption. They also seem to be more conscious about striking the right balance of equities between the investor and the state, whose officials have been taking bribes. For example, the Metaltech case can be contrasted with the case of Kiran, again against Uzbekistan. The award came out in 2017. In that case, the claim was brought by a group of Kazakh investors in Uzbekistan who had purchased 2 cement plants, which were later nationalized. And Uzbekistan argued that this investment was tainted by the fact that the Kazakh investors had paid allegedly an $8 million bribe to Gulnara Karimova, who was the daughter of the president of Uzbekistan at that time. And also they had paid $3 million to a well-connected Uzbek businessman who allegedly used these funds to influence the government. And the payment to Ms. Karimova was made by way of an overpayment for the shares that the investors purchased from her. Uzbekistan argued that red flags were present in that case, and the tribunal should find that it has no jurisdiction. The tribunal disagreed. In order to establish whether or not bribery had taken place, it applied the criteria set out in the Uzbek criminal code, and it found that it couldn't establish with reasonable certainty that there was indeed an overpayment. It also could not establish that Ms. Karimova was a government official at the time when the alleged bribe was paid. And finally, there was no evidence that she somehow influenced the government in a way so as to give an advantage to the claimants. So it could be said potentially that the Kim tribunal took a stricter approach to assessing the evidence of corruption before it. And another very interesting case of a tribunal dealing with corruption allegations, again involving Uzbekistan, is the case of Spentex against Uzbekistan. That the award in that case is not public, but it has been reported by the legal press. In that case, again, there were allegations of corruption by the committed by the Indian investor. And the tribunal joined the dots and found that it looks like corruption had taken place. But it was so reluctant to allow the state to benefit from this finding that it effectively imposed a penalty on the state while rejecting the claim by the investor at the same time. It ordered the state to either donate $8 million to the UN's anti-corruption fund or to pay the costs of the proceedings and reimburse 75% of the investor's legal fees. And I have actually heard two of the tribunal members in that case, Brigitte Stern and Stanimir Alexandrov, speak with a lot of pride about the solution they came up with, and each of them tried to say that it was him or her who came up with that solution, which is quite ingenious. The only problem with that is that, in principle, it pushes the strict jurisdictional boundaries of an investment tribunal, as the state is being ordered to do something which goes beyond the boundaries of its obligations under an investment treaty. However, I understand that in that particular case, Uzbekistan complied and voluntarily made the payment to the UN's anti-corruption fund and did not contest this order. I note that I don't have a lot of time left, and very briefly, I will mention the recent case of Nico and Bangladesh, in which the tribunal again issued a decision which was quite skeptical of the corruption allegations raised by the state of Bangladesh. The tribunal found that in that case, there was no evidence that the payments made to various consultants were bribes. They even considered that the fact that the investor purchased the car for the head of the Bangladeshi state-owned oil company was not a bribe. And some of the allegations were raised only after the arbitration was commenced and no local officials were prosecuted. So that in the eyes of the tribunal really undermined the credibility of the corruption defense. And the tribunal also made a very interesting observation, saying that if it had been upheld as presented by the respondents with insufficient evidence, the corruption defense would have given them the unjust advantage of obtaining the gas that was delivered by the investor without having to pay anything for it. And they said that granting such advantages to the alleged victims of corruption, the state, cannot be the purpose of the fight against corruption. To conclude my remarks, it seems to me that after the high watermark of the Metal Tech Award, tribunals have been less receptive to corruption defenses raised by states. And it seems that tribunals have found such allegations to be particularly unconvincing when they are not accompanied by prosecutions of culpable officials and when they are only raised after the arbitration was commenced. It also seems that many tribunals have been influenced by considerations of equity, but they are effectively shoehorning these equity considerations into the evidentiary assessment, like the tribunal did in the NICO case, saying that it would have been unfair to find that the investor cannot be paid based on insufficient evidence of corruption. And in this way, tribunals are trying to rebalance the harsh consequences of following the principles set out in the Metal-Tech Award. Going forward, I expect the tribunals would be even more conscious of maintaining the balance of equities between investors and states on these matters. But the present framework of BIT jurisprudence offers them quite limited opportunities for doing so, and including specific provisions in investment treaties dealing with corruption on behalf of both the investor and the state would probably be the best way of addressing these issues. And I understand that Islambek will talk about such provisions in Uzbekistan's model bilateral investment treaty. Thank you.
Thank you, Evgeniya. That was enlightening and a really interesting take on the topical issues that come up in investment arbitration and how these disputes arise. I have one question for you before we move on to Islambek for his presentation. And for our viewers, you can enter comments or comments as questions, and we will see them and we can engage with them as we go through the session. So the question I have for you is actually a combination of two questions that were presented. And I wonder if you can address how the principle of due diligence and also separately how the principle of due process might play out in the context of some of these disputes that involve corruption.
Sure. So in principle, the tribunal would expect the state to carry out certain due diligence and to prosecute primarily officials responsible for accepting bribes or extorting bribes, but also potentially investigating the misdeeds of investors before these issues are brought as defenses before investor state tribunals. In terms of due process, again, one could envisage a situation where a state basically finds a scapegoat, finds disgraced government officials as a result of change of government, change of regime, or basically stitches up a case against an investor saying that the investor paid a bribe, framing the investor and then expropriating the investment on that basis. And in this situation, there would be a manifest lack of due process, and that should not be deemed as an acceptable basis for a corruption defense.
Thank you. So let's take this lens and make it a little broader, continue to be forward-looking based on these experiences, whether it's in certain substantive areas or otherwise, and turn to Islambek, who will continue to address this question. Does ISDS still remain fit for purpose? And how do the various model BITs, emerging toolkits, emerging protocols help support that process? And I understand Islambek's going to take us to Uzbekistan and give us a focus on what the model BIT and some other developments there might teach us. Islambek, over to you.
Thank you very much, and good afternoon, everyone. I'm very glad and very honored to speak in this Bishkek Arbitration Days conference, and I would like to mention that it's always very interesting to hear about the Uzbekistan cases, and knowing that you represented in these cases your state and you know all the details, and it's always very interesting to hear about these cases. And as you can see, and as Evgeniya mentioned, there's a lot of Uzbek cases which became like the most popular, and there was several such awards on these cases, in which it was like the first time in the practice of the dispute resolution, investment dispute resolution. And on the question, is it still fits the ISDS, is it still fits the states and the settlement of the investment cases, I can mention that the last 2 years I was representing Uzbekistan in the third working group of the arbitral on the ISDS reforms, and I can say that the states, the representatives of the states, they are not satisfied with the situation in the ISDS at time. Just maybe several reasons on that. We sometimes even don't understand. Is it still the dispute resolution, or it became like a justice? Because there's a lot of issues with the competence of the tribunals, as was mentioned by the Evgeniya. In some of the cases, like Federal Electric and the Spantex case, does the tribunal has such a competence to make such award, like to make a penalty against the state, on the state? And there is a lot of such issues and discussions around the states on the competence on the international arbitration, and if there are any importance of adopting or establishing of some international investment court, not the arbitration, but maybe it should be a court. And also, as everyone knows, that the basis for such investment cases are the bilateral investment treaties of the states. And because of that, according to the experience of Uzbekistan in the sphere of investment arbitration, according to the cases which we had and analyzing other cases, there was a working group, and I was like the head of this working group on preparation of a new model BIT of Uzbekistan, according to the international experience, best practices, and the experience of Uzbekistan in investment cases. I will just share my presentation on that, if you don't mind. And just a moment. So I think now you can see my presentation on the investment on our model BIT. Maybe just some words on the background, that the first BITs of Uzbekistan signed in 1992 after the independence of Uzbekistan. So Uzbekistan became independent in 1991, and today Uzbekistan has more than 50 BITs. In 2019, there was prepared in several years its model BIT, and that's, as I mentioned, based on the ISDS experience and the best practices. So you can see the list of the investment treaties of Uzbekistan. Now there are 55, but not all of them are in force. Some of them are not in force. And I can mention that as I showed, that the first BITs were signed in 1992, but these BITs are not good. So we have a lot of cases with Turkey based on the BIT with Turkey, but this BIT has a lot of challenges in its text, and there's a lot of issues on the cases which we have with this BIT. So what was the key documents on the preparation of the our model BIT? So in this process of drafting of new BIT, our team reviewed numerous documents and model BITs and national investment laws of different countries, as well as tons of investment arbitration cases were analyzed. And we can say that there was the 4 main documents that you can see on the screen on the presentation, and these 4 documents, as we believe, contains key elements providing for the promotion, facilitation, and protection of foreign investments. So that became the main key documents in the development of our model BIT. In the main goals, you can see in this presentation the main goals of the model BIT. And we can say that they being an economy in transaction and developing country, Uzbekistan needs an influence of the foreign investments, and that means that we need to give a protection for the investments. However, for this investment data must be long-term and sustainable. In the process of preparing of the draft model BIT, one of the most important goals that our team set for itself was promotion and facilitation of long-term sustainable foreign investments. It is therefore important that BITs are drafted carefully with a view to the allocation of benefits and represent responsibilities for years to come. Well, definitely, the policy and regulation frameworks establishing clear parameters are crucial, especially for Uzbekistan. Another important factor that was taken into account, as you can see in the speech of Evgeniya, this is the corruption allegations. In model BIT, we included a special criteria and articles on the corruption. The fight against corruption, this phenomenon, in our view, and also considering the international practice of investment disputes and practice of Uzbekistan, one of the most important tasks of our BIT. And that was also raised in the Spantex case, in the award of the tribunal in the Spantex case. Of course, the investors will want to invest their money without guarantees of protection, and they wouldn't like to do that. And safely, they would want to have a safe investments. So another very important aspect of the new model BIT of Uzbekistan is that it provides foreign investors with the guarantees that their investment will be protected, thus making investment more lucrative and attractive. You can also see there was a new definitions in our model BIT. This is the asset-based and the enterprise-based approaches. In the process of studying various BITs, especially Uzbekistan, we noticed that the definition of investment is too broad. And usually the definition covers every kind of asset or any kind of asset, accompanied by a list of examples. For example, Article 4.1 of the Greece-Uzbekistan BIT defines investment broadly to include any right conferred by law or contract or by virtue of any licenses and permits guaranteed pursuant to law to undertake an economic activity. Such a formulation is broad enough to capture a large number of contractual rights and may elevate to the whole contract into the realm of international treaty protection. And there was a lot of approaches and issues in such our cases with the BIT texts on these issues. So therefore, believing that the protections under the state contracts should only be granted to investments which are long-term in nature and have a substantial connection with the economy of host state, we decided to shift towards enterprise-based approach and incorporate the definition of enterprise into the BIT. So this is, I think, the main approach in this one of the main approaches of our BITs. And also, as it was mentioned before, the anti-corruption provision is one of the most important provisions. As I mentioned before, that the problem of corruption and bribery is one of the most pressing issues in the modern day Uzbekistan, and we have a long history of disputes with the investors due to their bribery practice. As it was mentioned, the Mittal-Tech case now is one of the most popular cases. And when the states would like to prove the situation with the bribery, they always use the Mittal-Tech case to use as the proof their situation. But as you can see in the very similar situation in the Kim case, the arbitration tribunal, they didn't accept the bribery and the corruption issues, and there was allegations and situations which were mentioned by Evgeniya. And therefore, the new model BIT includes anti-corruption provisions that it is envisaged as a contribution to the eradication of corruption.
Islambek,
yes?
Can I interrupt you for one moment? Can you move your slides forward?
Just a moment, yeah. So you can see the slides?
We can see the slides, but they're not moving forward.
Oh, sorry. I was thinking that you are seeing that. Thank you. So I was just telling about the anti-corruption provisions. As I mentioned, we have a lot of cases with these anti-corruption provisions, and now we would like that there will be a specific rulings in the BIT which will allocate to these anti-corruption issues and which will show the investor, also will give the information and instruction to the investor that there is an anti-corruption provision in the BIT. And that will be also like maybe helpful in the settlement of the investment cases if there was an corruption issues. And you can see that the next one, and also the human rights and customary practices, labor legislation and environmental protection were included to the BIT. This is also a very new thing for Uzbekistan, and there before in our BITs you can't see such an provisions and such a norms articles on the protection of the human rights, labor legislation and environmental protection. This is also based on the international practice and practice of best practices of foreign states. And you can see the practice of the several states like Ecuador and Peru, in which they use such provisions and such norms in their BITs and international standards in their investment cases, where they gave a counterclaims on the environmental protection issues and they won the part of the amount in the case according to their counterclaim on the environmental protection. So that's becoming very actual and very useful in the investment. So these issues are also very important and were included to the model BIT of Uzbekistan. And in the next slide, you can see the institutional governance. So this is another practice that never existed before in Uzbekistan BITs. This is the introduction of the institutional governance. We did so by adding a provision on joint committee whose aim is to administrate the agreement, monitor implementation and execution of the agreement, debate and share opportunities for the expansion of mutual investments. And this is also one of the new ways of the dispute resolution which could appear as a joint committee. According to our view of agreement, joint committee shall be composed by the representatives of both parties, and the states would be like in interest and help to solve the issue which their investor has and which can bring the arbitration case or into some other issues for the parties, some other cases for the parties. And we think that this such new body like institutional governance as a joint committee will be a new helpful institution and will be helpful to solve the arbitration cases and solve the ISDS solutions and problems. And the main thing, finally, we have introduced mixed system of dispute resolution in our model BIT. So according to the new model BIT, dispute resolution system consists of three main stages. This is negotiations. It could be consultations and negotiations through joint committee and direct negotiations between the state and the investor. Then we included like mediation procedure. There wasn't before in any BIT of Uzbekistan, so now we included to our model BIT the mediation. And the last one is arbitration. So there are also in arbitration, like the exit is still like the main possibility to solve is through the arbitration, but we also included to our model BIT the possibility to go to ICC, and we're thinking to include also maybe in future some other institutions for that. But at time the exit, ICC and ad hoc is the main possibilities to go to arbitration. But we also showed that the parties could negotiate and come to opinion and like go to some other arbitration if they are ready to do that. because every state, like in investment arbitration, they know that the ICSID becoming very expensive for solving the investment arbitration cases, and this is very actual to have the opportunity to go to some other arbitration institution to solve the investment case. And in Uzbekistan, there was adopted a new law on investment, and in this law, these provisions were also included, and also included the issue of the exhaustion of the local remedies. This is included in the law, but in the BIT, we didn't include the exhaustion of the local remedies. So this is the main information about the model BIT of Uzbekistan, which were drafted, and at time it is used in negotiating with several countries, and mostly at time we negotiating with Belarus and with the United Arab Emirates. So this BIT were used with them in concluding BITs with them, and it is under negotiation with several other countries. And we will use this model BIT during the improvement, like resigning our BITs with other countries. And going forward, I would like to say some words about the ICSID draft code of conduct. As I mentioned, I was representing, so I'm still representing Uzbekistan in the working group 3 of Ancitral. And in the Ancitral working group, there is a lot of negotiations on the how we should go to improve the ISDS system. And in this regard, ICSID also are going to improve their system. So they are working on the improvement of the rules of ICSID. Then they would like to begin to improve the convention, Washington Convention, and also they are preparing such a draft code of conduct. And at time it is under the negotiation how it will be used, will it be adopted or not, and going to the background. So it was announced on 1st May and was prepared by the ICSID and the Ancitral Secretariat. And for the most interesting thing that it seeks to address a range of ethical issues in investor-state dispute settlement. But it is really under real negotiation around the representatives of the states. And of those issues are of particular interest, and we can see that it is the disclosure obligations, double hatting, the practice of acting as both counsel and arbitrator, repeat appointments, issue conflict, and this is the main things. And undoubtedly that the code is an output of an valuable long-standing efforts, even though it doesn't have any binding force at the moment. It is yet to be seen on which provisions of Working Group 3 members agree and what kind of modifications will be seen required. What is certain, due to the mounting pressure for ISDS reform by the international community, is that such proposals are not destined to be entirely ignored. So that was like the main things which I would like to give and to speak on. And so I'm very happy to answer to any questions if you have. Thank you for your attention.
Thank you, Islambek. There are some really interesting ideas in what you've presented, including this idea of institutional governance, and in the same vein, this idea of a code of conduct, and how do these decision makers help resolve disputes between the various stakeholders. As I mentioned at the outset of this session, that is one of the key criticisms of ISDS, or both of those are key criticisms of ISDS. So to create this kind of mechanism is a very forward-looking solution in Uzbekistan and through its model BIT. We're going to now turn to Kabir, and I have a question that I'll pose to him that's come out of some of the comments that you've presented, Islambek. Kabir is going to address some of the EU perspectives and EU solutions, the European Union solutions to the debate and to some of these fundamental systemic challenges that are being faced by the ISDS model at the moment. And in doing so, Kabir, as you talk about some of the solutions, it would be very interesting to also hear how some of these ideas that Islambek's already addressed interact, including this institutional governance idea, and also code of conduct, and also selection of adjudicators, things along that nature. So with that, Kabir, I turn it over to you.
Thank you very much, Kiran. Very grateful to be here. Good morning, good afternoon, good evening. Might be good night for some people. I'm very, very honored to be here. I speak, I think, on behalf of all of us that we would much rather have preferred to be in person in Bishkek, enjoying Besh Parmar, love. The reality that we are all in means that we have to manage the way we are. Kiran, may I request you to give me a shout out if you can see my presentation?
Yes, I can see it. Thank you, Kabir.
Fantastic. And Kiran, I will likely screw up at some time. This is not you, this is me. If I do that, please feel free to intervene.
You got it.
As Kiran mentioned, right, our fearless moderator, we've heard our prior two amazing speakers talk about issues and talk about them with the focus on Central Asia, right? Evgeniya spoke about corruption. She gave us a lot of very poignant examples from Central Asia. We had Professor Islambek speak to us about Uzbekistan's experience. I'm now going to be trying to discuss what do we see happening globally, right? This is what Kiran mentioned. I will look at the European Union and look at a few other examples. What is the state of ISDS globally, right? Because in some senses, this is a global regime. It's a dysfunctional and a disjointed regime, but it's a regime nonetheless. So what are we seeing other key stakeholders doing? And I will begin first by looking at predominantly what the European Union is proposing. And I'm giving the examples of the TTIP, the Trans-Pacific, the TTIP, this is involving the European Union and the United States, and then CETA was the European Union and Canada. The proposals by EU are more or less similar. And what is the idea? The focus is predominantly on dispute resolution. There are fixes made in tightening provisions, but the focus is really on dispute resolution. And the idea looks something like this. They're talking about replacing the mechanism that we have, the investor-state mechanism, with what is called as a court structure. Now, I use the word court in quotes, and you will see why. But what is the proposal? The proposal says, you are going to have, and here's where you see language becoming interesting. It's court, but they call it a tribunal of first instance. That will comprise of 15 judges, 5 from EU, 5 either from US or Canada, depending whether it's TTIP or CETA, respectively, and 5 from the rest of the world. Kind of the way Europeans and Americans, Canadians like to see the world, right? So you will have these 15 judges. These 15 judges will be appointed by states, right? You will be appointed for 6 years, renewable once, so 12 years in total. But it's not going to be 15 people sitting at one time. Of these 15 people, you will have a chairperson who will pick up 3 people, right? One, and one from the division that we have that will hear disputes, right? So it is, think of it, one way to think of it is it's arbitration from a very narrow set of people that are elected by the states. And people who are going to serve on this tribunal of first instance cannot do anything else. There are fairly strict rules. If you're a judge, this is what you should be doing. And to that, you will be, you will be paid a retainer of 2,000 euros. This is hashtag a first world problem, but the arbitration community keeps telling us, oh my God, who's going to want to sit on this for just 2,000 euros? Hashtag first world problem. Now, why is it a court? It is a court because you have a tribunal of a first instance, and then you will have an appeals tribunal, right? So you have now one body, and then you have an appellate mechanism. The appellate mechanism will comprise of 6 members, 2, 2, and 2, following the same format that we had. I guess the Europeans are moving on the premise that you're going to have fewer appeals, so fewer judges are necessary. Anyone who has practiced will probably tell you that if a party can appeal, they probably will. Hashtag future problem. Again, this is going to be for 6-year divisions. So 6-year renewable ones, 12 in total. You will again hear cases in 3. You will be paid here a monthly retainer of 7,000 euros. If you have a choice, sit on the appeals tribunal, you make considerably more than the tribunal of first instance. But I just want to point out one thing here. Like, the idea here is an interesting and a responsive idea, but it doesn't address best practices on many things. And one very critical area where it doesn't address best practices is on diversity. There is no talk on diversity in either of these bodies. And, I just compared this to the Rome Statute creating the International Criminal Court. The provision there said, when you are going to appoint judges, think of women. That's all that's required. Just think of women. And you look at the International Criminal Court, and you will see that most of the senior officers are women. We have not done that best practice here, and it is deeply problematic. In fact, the reality is that when the European Commission put forward potential names to sit on the CEDA court, there was not a single woman. Now, if we're talking about representation, you're omitting half of the world. And if you cannot find capable women, you're not doing your research well enough. Come to me, I'll give you a lot of names. You have 3 of them on this panel right here who can manage these disputes perfectly. So this is the European proposal. What do Americans, or famous Americans, tell us? Now, the United States government has not taken a very vocal position on this, probably emblematic of things in the United States, but we have some prominent American arbitrators. Just one point, the European Union is taking this court proposal very seriously, right? You see the famous statement, ISDS is dead. Right, so they are very serious about this idea. Judge Brower, a very, very prominent American arbitrator, talks of this 15-judge proposal as a monstrous 15-headed hydra. You have to give him full points for being creative. This is what he thinks the court proposal looks like. We had these very prominent arbitrators from Europe, Kaufman Kohler and Michele Potesta, who have actually supported this idea in a very famous proposal that is being considered by the Working Group 3. And he's actually fairly critical about what they're doing. Why are you trying to destroy this ISDS regime that we have created? He also called, it was bound to happen sooner or later. He called the investment code proposal fake news. And Judge Schwebel, another very prominent American arbitrator, says, this system is now potentially creating a bias in favor of states, right? The criticism so far has been that the system tends to favor investors. He's saying, are we going too far the other way? How serious is Europe? This is just very timely. This happened exactly a month from today. The 23 EU member states have signed a treaty to terminate all intra-EU BITs. This happened following the famous Achmea decision. You cannot be in this field and not have heard of the Achmea decision. And the EU states have actually agreed to terminate all the treaties among themselves. And it's very significant because these treaties have sunset clauses that give the treaties a very long life after they are terminated, right? It's generally 15 to 20 years. This treaty terminates the sunset clause as well. So when the treaties are terminated, they terminate immediately. Now, 4 countries have not signed it: Austria, Finland, Sweden, and Ireland. Remains to be seen what's going to happen there. It does not apply to the United Kingdom, of course, after a very, very, very long drawn and painful process. I'm sure Evgeniya and Monica, both being in the UK, can attest to how painful the Brexit debate was. They have decided to leave the European Union, and so this treaty doesn't apply to them. Now, for Central Asians, this is significant because this treaty does not extend to the Energy Charter Treaty, the ECT. And all other 5 Central Asian countries are part of the ECT. So this termination treaty applies only to the Europeans. It doesn't extend beyond that. It remains to be seen what's going to happen with the ECT. I know we're probably running short of time, so I'll try to thumb through the remaining sections relatively quickly. But just to give you an idea that the landscape is very confusing. We see this proposal for the Europeans where they're talking about courts. But then if we look at the CPTPP, this is the countries on the Pacific Rims. This is a treaty that was created by them. The United States was going to be party to this treaty till the presidential elections took place, and then the US withdrew. The TPP then became comprehensive and progressive. Case in point here. Take the United States out of anything, and it becomes comprehensive and progressive. Now, if we look at the dispute resolution mechanism here, the dispute resolution mechanism, even though Canada is a party, contrast this to CETA that we just saw, you have ISDS the way we understand it. So if you're looking for consistent state practice, we have one model where Canada says no ISDS. We have another model where they say ISDS seems like a good idea. You have another model, and this is the new NAFTA, the North American Free Trade Agreement. It's been renamed now with a horrible abbreviation. It's USMCA. Good job coming out with a horrible title. Again, this is United States, Canada, and Mexico. And here you are retaining ISDS in a very limited form with a very unique scheme. Between Canada and for Canadian investors, there's going to be no investor-state dispute settlement at all. Now, Mexico, you can rely, because both Mexico and Canada are party to the CPTPP that we just saw. So you can probably use the TPP investor-state dispute. United States and Canada, there is no international dispute resolution mechanism available. You have to go to courts, or potentially the states could take up your case. US and Mexico, on the other hand, will have very limited investor-state dispute, only for national treatment, MFN, and direct expropriation. Now, I just point out for what it is worth, if you're familiar with the jurisprudence, MFN can do interesting things. It allows you to import things. The query is, will the MFN actually expand what the US and Mexico have listed here? Remains to be seen. Other countries have come up with some creative ideas here. Brazil, which never signed any treaty, today has started signing treaties. It doesn't allow investor-state dispute. But Brazil is suggesting that if there is a dispute, the final remedy is going to be state-to-state arbitration, right? This is what used to exist, right? Diplomatic protection. Your state espouses your case. It was seen as being problematic, and that is why investor-state regime was created. We're now potentially seeing a very significant country here saying, no, we don't think ISDS is a good idea. Let's have diplomatic protection. Just finally, we have India. India, again, a very populous country, large size-wise, but larger if you think about population. India has rejected the European proposal. And what is India's approach? India's approach is you can have ISDS, but you have to exhaust local remedies first for 5 years. So only after you try local remedies for a very long time, as a person of Indian origin, 5 years in India is not a very long time. The courts tend to be slow. Most other countries, people would probably disagree. But this is the Indian model. And India had like 80 treaties, 84. India has terminated 60 treaties insisting that if you want to have a treaty with India, you have to agree to this 5 years. And that takes me to my final point. What is the global landscape? We don't know. It's a confusing time. We don't know if ISDS will exist in the future. If it exists in the future, we don't know what form is it going to take. Will it be a court? And if it's going to be a court, what do you do to countries like Brazil, India, large developing countries that may have a significant say in how policy might be framed? This generally fits into the discourse of nationalism, protectionism, right? That we're seeing happening pretty much all over the world. ISDS is just one such critical factor that's falling within this paradigm. So it remains to be seen. It's an exciting time if you look at world as being a glass half full. It's challenging if you are a pessimist. With that, it's been a real pleasure to be here, and I'm going to stop. Thank you very much.
Thank you, Kabir. I'm going to pose a few questions to you, and one of them is only for you, and then after that I have a question for both you and Islambek. The first question, you talked about new NAFTA. I call it USMCA, not USMACA, but I've heard lots of interesting views on that acronym. But the new NAFTA is quite notable from a Canadian perspective, not only because of Canada's lack of participation in Chapter 14, but actually also because of Canada's participation in CETA's ISDS provision or ISDS mechanism. So I wanted to get your views on what that means for the future of ISDS. Here we have a sophisticated nation that has significant ISDS experience, significant ISDS expertise. And in one particular negotiating scenario, they have abstained entirely. We can say it might be because of lack of bargaining power or other reasons, or they felt they wouldn't get a deal that they'd be comfortable with. Or frankly, it might be coming back to what I've called before the experiential reality. They have not had necessarily a good experience under old NAFTA. So why be a part of new NAFTA if you can get out? But meanwhile, in CETA, they are participating. So what does that duality mean? It means that we don't have an all or nothing approach, at least in one country's perspective. And it also means that ISDS is not dead, hopefully. So what do you think?
Thank you, Kiran. That's such a great question. I wish I had a very erudite answer to it. I'll make one general point. My first general point is that, we like to think that states have very well thought out, consistent policies that they apply in a very systematic manner as a matter of principle. The reality of the date is that states tend not to do that. They tend to be competing lobby groups. It's tough being a government, having worked with a lot of them. They're competing interests, they're lobby groups, they're your constituents you're trying to respond to. Canada, I think, is a very, very confusing example because if you look at CPTPP, TTIP, and USMACA, USMCA, you see three very different models. But I think you see things like that happening globally. India took a position. We are not going to sign any treaty unless you agree to 5 years. India, in January, signed a BIT with Brazil. There's no requirement for 5 years. It says state-to-state arbitration. So I can give you any number of examples of countries that say we're going to do this. Australia, case in point, we're going to abandon ISDS. Not really. Indonesia, we're going to abandon ISDS. Not really. We're seeing that happen globally. In Canada's case, I don't know a very polite way to say this, but this is a common theme we've heard in the United States. US, Canada don't need a BIT. Both our courts are very sophisticated. Now, that's deeply troubling if you're looking at us as being a comity of nations and, the same rules applying to everybody. But the argument here is that these two countries are similar. With Mexico, at least when it came to the USMCA, the argument always was, well, we have the CPTPP. You can use ISDS there. So,
Thank you. Okay, one more question. And this is, Kabir, one thought from you, and then from Islambek, because I do want to keep us on time for this panel's conclusion. So what about the problem of repeat appointments? I talked at the beginning in my introduction about the problem, about the element of repeat players. I didn't describe it as a repeat appointment problem. I was referring to the broader idea that we have repeat states, repeat investors, repeat counsel, but we also have repeat arbitrators, repeat adjudicators, and now with this new court model, repeat judges. What does that mean? And is that a problem?
Kiran, you're asking very difficult questions. Look, to the extent we believe that double hatting is a problem, right? And from a perception perspective, it definitely doesn't look great that you have people who are, arbitrating cases as an arbitrator and then arguing very similar issues. We're talking about 8 or 9 legal buckets, right? That's the standards, right? It's expropriation, FED, MF, and they're just a limited pool. And, you can make outcome determinative, unintentional. I don't think people here are sitting, let me screw people. You can make unintentional. It's hard to shut off things in your mind, right? You're sitting as an arbitrator in the morning, arguing cases. From a third-person perspective, that's not great. So to the extent you believe in that, the court proposal is an improvement. If you look at this as a rights issue, people are not entitled as a human right to select your judge. There is no human right to selecting your judge. That is a reality we have created in arbitration, and there's a lot of merit, but you're not entitled to that as a human right. There is a diversity problem here, and I fully acknowledge that you're probably not going to allow younger people to get a chance to become arbitrators if it's going to be a court. I do take that point fully, and it's probably going to affect women of color when you're a double minority or an intersectional minority greater. But there are mechanisms you can try and address that problem. It ultimately boils down to, what do you think is the core value that you want to protect? Is it appearance of bias and thereby legitimacy? Is it diversity? It boils down to, what is the core value and issue?
Thank you, Kabir. What do you think, Islambek? Do you think that you brought up the idea of double hatting, you brought up this new code of conduct that was unveiled about a month ago. What do you think? What's the solution? What are maybe what's the value we should prioritize in your view?
So I would like to begin by giving a little comment. During the discussions on these ISDS reforms, what was the idea of creating of a court? The main idea is that the ISDS at time doesn't fit to the interests of the maybe states or both sides, like states and investors. Why? Because at time we have a list of arbitrators who are always appointed by investors, who always take the side of the investor, and the list of the arbitrators who are often appointed by the states and who show themselves like arbitrators who act on behalf of the state, as I mentioned, and also such arbitrators who act on the behalf of the investor. They're using this situation, like their image as a pro-investor or pro-state, to be appointed in the arbitration, and this is also a business for them. They earn money for that. And this is the idea of the court. There wouldn't be an arbitrators who are appointed by the sides, by the parties, and they will be totally independent, where they will have a salary given by the court. They will be paid by the court, not by the parties, not by the other situations, etc. So that was the main idea. So because of that, the problem of the double hatting, of the reappointment of the arbitrators, we have such a problem. And it's very hard to discuss that. In my own practice, I saw such an arbitrator who were acting not like arbitrator, but like a counsel of the investor. That was really bad. That was really bad situation, and you don't know how to protect yourself maybe in this situation. So this is are really problem. And but there is another issue on the court and in this situation. In the discussions of the ISDS reforms, the states, they are not interested, or they are not using or analyzing the interest of the investors. So will the new forms of ISDS, like the court, would be in the interest of the investor? Will the investor will be like willing or interested to go to the court? So at time, the arbitration, the ISDS forms which we have, they like benefit the investors because there is a third-party funders. It's a big business for many such funders and investors. It's real situation. But will it benefit them if it will be a court and if it will be a judges or not? So there is a lot of discussions that I think there will be a lot of discussions at time. The arbitral is giving the suggestion to make the discussions 6 times a year. So you know that it's twice a year, and now they are thinking about to do it 6 times a year to make it faster because it's going too slow. So we'll see how it will go. So there will be a lot of issues and problems.
Thank you, Islambek. So we've been talking primarily about not only hot topics, but also emerging topics. Although we've all been in the midst of COVID-19 and lockdown orders and stay-at-home orders and work-from-home policies, we've had a lot of progress, which is nice. The world doesn't end when the world is ending. In the same sense, though, we have to grapple with the post-COVID-19 world. So on that reality, on the basis of that reality, I want to turn to Monica, who has some comments on what ISDS looks like and how COVID-19 impacts the future of ISDS and the kinds of disputes or the international law issues that we might see coming up. So with that, last but not least, I turn it over to you, Monica.
Yes, thank you very much for the opportunity to discuss this very important, I would say, theme for all of us involved, not just in investment arbitration, but generally in litigation. WHO declared a public health emergency at the end of January 2020. And since then, we have seen an extraordinary and I would say unprecedented set of measures that states have implemented in order to deal with that emergency. Now, there has been a major criticisms to some of those. Here in the UK, we had Lord Sumption, a former Supreme Court judge, pointing out that at least here in England, those measures were amounted to the worst interference with personal liberties ever in our history in the UK. Lockdown measures may actually be, at the very center of possible claims. To give you an example, just to set out the scene, in the mining sector, there has been definitely certain positions that assert that mines are hotspots for threat of coronavirus. So imagine if a state takes a position that it has to control or it has to stop the function of the mine, would that amount to an interference or a breach of a obligation under investment treaties, in particular scenario. Now, in some countries, they have taken up the position that the mining industry, for example, supports manufacturing, including a number of health products, and therefore they have classified the industry as essential, and therefore didn't stop at all. So you have generally that potential I would say, situation created by crowds and in the construction industry, in the mine industry, and possible measures that the states may take. Now, here we are facing a number of important elements to look at. One would be the legality of the measure, duration of the measures, and the effect of the measures available. I obviously cannot cover all the fascinating spectrum that we may have to deal with. I like just to pose two big areas that we may want to look at if you are considering analyzing in detail an investor, or if you are on the safe side, either. Now, when it comes to possible investment claims, if you will have to persuade the tribunal that there has been a breach, for example, of fair and equitable treatment because of measure in the context of coronavirus crisis, or that amount to an indirect. Now, how do we look at this? We have a legal framework of, first of all, which has to do with, first of all, to look at the treaty exceptions. There may be a BIT that already contains exceptions when it comes to the possible room that the state has for regulating, for example, a public health emergency. You have to look at the treaty, first of all. Now, some of the BITs contain provisions such as the following. Where, for example, measures are allowed that are for the maintenance of public order. The treaty will not prevent a party from adopting or enforcing measures to protect human life or health provided by the measures. Basically here, measures that are arbitrary or discriminatory are not going to fall within this category, but some treaties have already made a number of public objectives legal under BIT's obligations. The second, but that's a very small amount of treaties. It may be the case that treaties are just silent about this room that the states have to regulate. And so then what you have to do is to look obviously into the customary international rules that this particular area. So one of those specific rules, we are very familiar, some of us, with them on rules of state responsibility. And in particular, three types of rules may be relevant. And that is the rule of force majeure. These are all secondary rules of state responsibility. Majeure, distress, and a state of necessity. Now, with the exception of a state of necessity, which has already been raised in particular when Argentina lived through a crisis in the early 2000s, it raised in a number of cases the issue of necessity. But with that exception, force majeure and distress have no feature in the investment arbitration cases that we know. Therefore, it is very much, a new area, and an area where potentially we will have to rely on other perhaps case law that has been produced and commentary to the state responsibility rules. So what could be the elements in the case of force majeure? I would say, as it is generally, there is already there are about 5 conditions to fill this possible exception. Number one, that there is an unforeseen event, which goes, number 2, beyond the control of the state. Third, that the event must make it materially impossible to perform the obligation. 4, that the state has not contributed to that situation. And number 5, that the state has not assumed the risk of the situation. This is, as you can see, a very difficult hit under public international law, and in particular, look at the element number 3. You have to prove that it was materially impossible, the performance of the treaty. Now, turning to necessity, necessity has for number 1 that there is an imminent peril. We could argue that COVID, it is something imminent. Threatens. Number 2, that this threat threatens interest, and this is this notion of essential interest has already been raised in the context of investment arbitration. For example, the well-being of the population is as an essential interest, and this was the case in the National Grid versus Argentina investment. That the state's act must not seriously impair another essential interest. And the other interest, obviously, is the investor. So here there is going to be an analysis to be made as to both interests and a balance in that sense. Number 4 is the criteria, the requirement that the state actually could only but take that measure was the only way to safeguard the interest from that peril. And this is going to be a key test and a difficult way, but nevertheless quite crucial. Is that the only way how you can achieve that objective? Now, turning to the final element, distress, there are a number of possible, here again, elements, criteria that have to be fulfilled. There are 5 indeed. For example, that there's a threat to life, and here we could say that that requirement, is there when we talk about coronavirus. Number 2, that there is a special relationship between the act itself, can be attributable to the state. Number 3, that there's no other reasonable way to deal with the threat. And so this is a test reasonableness. Number 4, that the state is contributed to the situation. And number 5, that the measure was proportionate. So I can imagine, for example, that this exception of distress may be on situation, the mining case I was referring to. But there will be a number of tests that will have to be satisfied, which are not, we don't have a lot of previous case law where we could actually, build on. So it's all going to be a new territory charter. So, generally speaking, what has been happening since? I mean, we are not any longer at the beginning of the crisis. We are already some months into it. So in what way has already, coronavirus impacted the work that we do in investment arbitration? Certainly, there has been already a number of situations that have created the possibility of claims in Mexico. For example, we have had that situation. What has happened in Mexico following that the government took a number of measures restricting renewable energy production on the basis that there had been a fall on the demand caused by the pandemic. Now, that has been criticized strongly by the private sector, by the investors in this area, and potentially this is already creating a wave of cases. There has also been some legislation passed by Mexico in the electricity industry, and this again, it is another, it is controversial. The justification is always the pandemic, but in closer inspection, this will have to be. In fact, it was, for example, the state could achieve the objectives that it was pursuing, among others. Now, there's another big important sector that will be relevant in the context of coronavirus and investment work, not so much, well, not relating to new claims, but rather to the very important area of enforcement. And we have already heard of a case in Washington, D.C., where a state actually raised the issue of coronavirus as a justification for not enforcing a particular, was the case of Guatemala, in the case of TECO versus Guatemala. So basically arguing whether it shouldn't be a state because the paying for this award would deprive the state of the resources to fight the virus concretely. So you have all this mixture of extraordinary situations and the law trying to now perhaps serve as a way of assessing, how far a state can really go to actually implement measures in order to, how far the power of the state can go in the context of crisis. In conclusion, I have to say that what we are living is really a new brave world for the future when it comes to cases. And this is not just going to be, I think, in the context of investment arbitration. I think generally, this is not something that is going to weigh rapidly, so we will have to live with it for a longer period of time. So the question is, how is this going to affect issues of enforcement? We are seeing this even, with companies now even challenging the quarantine measures. This morning, reading the newspapers, I saw that British Airways was considering a legal challenge against the government for the quarantine. So the longer measures last, will be an assessment of, is this really necessary? Is this really the only way? And then the states will have to be very prepared to justify measures in order to achieve objectives. Now, I think that in the long term, what is the case law that will be coming from arbitration is going to be a development of more precise standards for times of crisis, which we so far don't have. With the only that I mentioned, the Argentina crisis, where issues of a state of necessity were raised. From now on, we potentially will see this area developing farther in investment arbitration cases. And with that, I'd like to stop in case there is some interest to have a conversation or getting questions. Thank you very much.
Thank you, Monica. It's really interesting to see how, although we are in a completely unprecedented time, that there are lessons to be drawn from past experiences and how states have dealt with mandatory state measures or necessary state measures to preserve the status quo, preserve the future. One question that's come up, and perhaps this relates to the post-COVID-19 world as well, I think it also relates to the future of ISDS generally and new mechanisms and protocols that are being set up, is how do the national and the international, the supranational context interact? And I was wondering, Monica, if you have any views on how national legislation, national laws, national court proceedings might play out in the international stage, at least in the COVID context, based on some of the precedent experiences that you've seen or studied.
There was an interruption.
Okay, let me repeat the question. How do you see the national context and national disputes and national resolution interacting with the international context in the post-COVID-19 era?
No, I cannot hear.
Okay.
Can you type it?
Yeah, I will type it.
Sorry, it's not. For some reason, there is.
Can you see the question, Monica?
Sorry.
Okay, let me in the meantime maybe turn to Kabir or Islambek if you have views, or even Evgeniya. I know you didn't address this necessarily, but you're very much engaging with this interplay of domestic and international. I mean, when we talk about stakeholders in any dispute, there are very many, and what we haven't talked about is that there are domestic stakeholders, including domestic judges or just domestic legislative authorities, domestic law enforcement authorities, and all of this interplays with the international context that we're very much focused on. So I'm happy to hear from any of you on this general idea. Kabir, do you want to go first?
Sure, I'm happy to go for it.
There you are.
Yeah, thank you, Kiran. That's again a very, very great question, a very challenging one. And again, I don't know if I have a super sophisticated answer. I don't know if one exists. Now, a couple of reactions that I would have is, the international dispute resolution mechanism tends to isolate itself from specific domestic provisions, right? You look at the ILC articles, you can't use domestic law as a defense. So that's one reaction I would have. Having said that, the reality of COVID impacts all of us. So I do think this is a unique reality where there's something that has pretty much affected everybody. As Monica, I think, very beautifully explained, this is a new reality everybody is confronted with. So I think to that extent, international arbitrators who are human beings also affected by this reality will potentially give a greater deference. There will be issues as to whether, it was proportional, whether, as Monica spoke about, it falls within the technical requirements of these defenses, right? Distress, necessity. But I think, this is a reality that has affected all of us. So I will put both these potentially conflicting views out there. It remains to be seen how it's all going to play out. But I do think it's not going to be the immediate measures. It's going to be whether the measures were proportional, whether they were applied in a uniform manner, whether, those are the sort of issues where I see we're going to see a lot of debates.
Thank you, Kabir. Evgeniya, what do you think? How does this duality play out? Maybe in the COVID context, but also in the corruption context, where you have domestic authorities, domestic legislation, domestic enforcement, all interplaying against and alongside in parallel, in often cases, to the international disputes, international proceedings, and international resolution.
Yeah, I wanted to actually echo what Kabir said. I think there's going to be greater deference accorded, and potentially we could look to the Philip Morris against Uruguay case, for example, where the tribunal somewhat controversially applied the doctrine of margin of appreciation in the context of a claim by a tobacco manufacturer and a measure adopted for health reasons. I think it's going to be something similar, and just generally, tribunals are not immune to considerations of publicity, and they would be aware that if they were to enter awards that criticize governments very severely for health-related measures, that could potentially threaten, again, the investor-state regime. So I imagine that we'll see tribunals going in that directions very broadly. Although, of course, as Monica explained, there are cases where measures are, tangentially explained by the relationship with COVID, but actually have nothing to do with that. So I think that's what I would say about that. In terms of corruption, there have been actually, I've seen some articles suggesting that we will see a rise of corruption and fraud as a result of COVID-19, with everybody stuck at home. Fraudsters apparently are having a field day, and somehow this might result in greater fraud, corruption-related issues in investment treaty arbitrations. I'm not sure I see the direct connection, but it seems that there might be issues around that. I think it's deference accorded to domestic state decision makers. Coming back to your question, Kiran, I think it is a bit different in the corruption context from contexts of measures safeguarding citizens' health, because motivations are quite different there. I think tribunals will continue to, both giving respect to genuinely run investigations against corrupt officials and investors, but also, potentially looking behind the motivations for such investigations, and, keeping in mind that not all of these are always done in good faith.
Thank you, Evgeniya. What do you think, Islambek? Do you think that there is, bringing the state perspective and the state facing experience that you've had, do you think that there is going to be maybe creativity or ingenuity behind the way that states, vis-a-vis their national courts or their national representatives or domestic procedures, deal with what's happening in the international context?
I think it's challenging, but there could be such a situation. I can see the practice of the CIS countries. And if we will see the practice of the CIS countries, the national courts could be creative in this situation and could find some rulings and position not to enforce like the supranational judgments or the judgments or awards of the international arbitration. We had such a practice in many situations, but the thing is why the investors prefer the international arbitration and ICSID, that they could enforce it in other states. And there is also a special international companies which research and find the assets of the country or the state and help to enforce the award and the such a judgment. But there could become some issues on the enforcement of such awards and judgments in the state. Even in Uzbekistan, Uzbekistan always enforces such arbitration awards, but even there is no any ruling or a law on how the ICSID award should be enforced in Uzbekistan. In the Washington Convention, in the ICSID Convention, you have a ruling that it should be enforced as the last award of the state court, like the highest state court, etc. But in the laws of Uzbekistan, and I haven't seen in the laws of the CIS countries, how they should be enforced in the country. We know that there is a New York Convention for the commercial arbitration and for other arbitrations, but there is always a possibility not to enforce and to be creative in this situation. So we'll see how we'll be in a practice.
Thank you, Islambek. I wanted to try Monica again. I don't know if it's working for you, Monica, but do you want to try and engage?
Yes. Let me just say something on this. Finally, as lawyers, we are advising and working with the law. We obviously believe a big principle, important principle in our practice is legal certainty. And I think that that's what has been taken away from us because of the crisis that we are facing. So this is where I believe that challenges of great nature will come in the context of litigation and dispute resolution in arbitration. Because and this is not something that may move fast. So this is not just a transition. There may be many things that will reaccommodate themselves. So our practice of arbitration right now is in a flux. I may leave that there. So it's a little bit of food for thought.
Thank you, Monica. So we have gone a little bit over time. I wanted to just take a moment to thank our viewers, our audience, whether they're contemporaneous or on a recording later, for their patience with us, for joining us. This concludes Bishkek Arbitration Days, virtual Bishkek Arbitration Days. So I hope that you've enjoyed all the proceedings during the course of these past 2 days. I wish everybody a good afternoon, a good evening, a good night, a good weekend. And thank you again for joining us. And we hope to see you in person somewhere in the world in the future. Thank you.